Now we've got to the part of today's session where we learn from the practitioners. I'd like to say a big thank you to the organizers of the event because they have gathered a very rich pool of practitioners. Sitting before us, ladies and gentlemen, dear colleagues, is about 2 centuries of distinguished practice, both in Ghana and abroad. And I will encourage everyone to take notes. The format for this session is we would have 2 senior lawyers give their presentations, and after that, we would have a question and answer session on those particular aspects of the presentation. So please note down your questions and we would have you ask them so that they can answer. To kickstart is a man who needs no introduction, a very distinguished practitioner of the law who is known both in Ghana and abroad. He is the senior partner at Benti Angel, Ace Anan Ankomah. Ladies and gentlemen, with a rousing round of applause, let's make welcome Ace Anan Ankomah. You can come up here, senior. Let the applause accompany him to the podium.
Thank you very much. Okay, well, how do I start? I have 10 minutes. Since I talk for a living, I'm likely to exceed it. So when it's 10 minutes, just tell me. The last time I was invited to speak, they gave me 10 minutes. After about 15 minutes, they told me 3 minutes more, and I told the guy, what am I going to do with the rest of the slides that I've prepared? I'm not going to use them for anything, so whether I like it or not, I'm going to give it out. But I have no slides today. When we speak of disputes work, I'm talking to you about disputes work. And one of my questions about legal training in Ghana is that it seems very biased towards disputes work. So you're learning all the criminal procedures and civil procedures and evidence, and it seems that that is where everybody goes. And in fact, I say that I have a lot of understanding from young lawyers who enjoy the legal soaps on TV, the Suits and others. But when I see a lawyer watching them, I'm very disappointed because it's nothing like the law. It's okay if you enjoy them as comedy, but to the extent that you believe that that is how the practice is, I want you to rid yourself of all of those dreams immediately because it's nothing like that, okay? It's not that dramatic. Now, disputes work will lead you into civil litigation or criminal litigation. It will take you into alternative dispute resolution scenes. So you're basically looking at arbitration, mediation, and sometimes some contentious disputes. So in some countries, what we call disputes is called contentious practice. I know you're used to the word litigation, but I think that worldwide, the word litigation is being downplayed, and the term disputes or contentious practice is coming up. It will also lead you to industrial tribunals, administrative hearings, white-collar defense. It might not be court, if you please the Lord, no. It might be appearing before IOCO or a regulator when your client, a company, has a matter involving disputes. How did I get into disputes? A bit checkered. I came home to Ghana and to join the firm I was kind of associated with before I went to school. I was away for just 11 months. And I was put in charge of the firm's tax practice because I had done grad school in international tax. So it was more of a corporate non-contentious practice, advisory, transactional. And after a couple of years, one day, so I made partner, and one day the then managing partner just called and said, Ace, take care of our litigation practice. And that was it. Now, I had very little disputes experience. So what did I have to do? I had to learn. Thankfully, this was around the time that the new civil procedure rules had been passed. So I took it and started reading it. And then, just around the same time, I got invited to teach at the law school. And after some back and forth, they asked, so what can you teach? I said, civil procedure. Why? Because I needed to learn it. And so I took the first year to the course outline and learned it while teaching it. Now, that's not the only time I've done that. When I came back, I was also invited to teach company law, and I didn't have a single note on it. And I took that year, topic by topic. And while teaching it, I learned it. So for a disputes lawyer, if you get the opportunity to teach anything disputes, take it. That's one of the best ways to learn, because you are forced to read, and then you make yourself better. And so when I started going to court, and let me encourage you, there's nothing, about this. I saw the seniors, the names. I was in awe. And I would hear them argue. And then I'll say, but I can do that. Yeah, I'm like that. Yeah, in fact, I can even do better. This guy, in my head, don't say it in your mouth. Say in my head, if he had given his brief to me, this thing, you understand? It's okay to have some verb. And so that's how it went. Case after case, matter after matter. But this is the secret, and these are the things. How do you become an effective and efficient disputes lawyer? Dress up and show up. That's it. Dress up or gear up and show up. This has nothing to do with 4-inch heels. This has nothing to do with the latest suit. I don't even know the names of the top suits people, because I've stopped buying suits. To me, it's working gear. I'll go to court and sweat in it. So I stopped buying those suits. The simple top, translate, you are fine. All right, dress up and show up. What does dress up mean? Prepare, prepare, prepare. Prepare, prepare, prepare. And there are 3 things in which you prepare. 1, the facts. You must master the facts. You must read the facts of the matter until the facts are coming out of your head when you are asleep. Because if you don't know the facts of the matter you are handling, you're going to mess up. You're going to ask questions on cross-examination and be exposed because you haven't mastered your facts. Even when law students ask me, so how do I pass my exams? I say, read everything 10 times. There's nothing you can forget when you've read it 10 times. Master the facts. How do you master the facts? There's the trap of chronology. On first March, this happened. On second March, this happened. On third March, that happened. When you are reproducing the facts, you can do that. But the better way to master the facts is to see if you can create a thematic flow. Because the chronology might not tell the full story. When you have built the chronology, see if you can build themes and subjects and issues from the chronology. Then you know that this has to do with consideration, this has to do with that, the 1st July and 31st, whatever, transactions are linked. And do you understand? You link them up into themes. It's one of the best ways to master the facts. You must be the master of your facts. In fact, when your senior calls you, you ought to, is the 10 minutes up? You ought to be able to say, oh, well, senior, you have mastered the facts. Now, if you move to a thematic understanding of the facts, then it is easy to do the legal review of the facts, because now you have themes, you have subject areas, so you know exactly where to go. You are not just running around like a headless chicken, not knowing what to read. And I tell you one thing, the subjects you didn't read, actually, the topics you didn't punch in exams, they are the ones you're going to meet in the first few days as a lawyer. All of you who used to punch questions, this was my solid 4, this is my conk 2. The ones you didn't read, they are the ones you are going to face. I'm telling you, that's how life is. And so, one rule of thumb, keep your lecture notes by you. All of you who have donated your lecture notes or sold it, go back for it. I think I have a witness in the house. Many have donated it, that I'm done. Go back for it. It is a wealth of information that you will require. So you master the law. It might be a pleading that you are drafting. I tell the young people in my office, I don't care how many times you have drafted a statement of defense. Whenever you are asked to draft a statement of defense, go back and read the rules again. If you are drafting a reply, go back and read the rules again. If you are doing a counterclaim, go back. Even when you are entering appearance, go back and read the rules again. At the very least, you get to revise the rules. And you never know when you need it. And there's nothing like the judge asking a question, and the minute she or he is done, you just roll out the relevant rule, and they are happy. I was moving a motion for extension of time. First, they were surprised that I came to court to move extension of time. At the Court of Appeal today, like, why are you here for this? But I moved it. And in the middle, Justice Ayene just went, but Mr. Ankomah, can you tell us the basis of asking us to extend time to file a reply to the respondents' written submissions? And without batting an eyelid, I said, my Lord, I refer to a Supreme Court decision which says, although there's no express rule, etc., etc., etc. Do you know that she had actually read that decision? Because after I referred her to it, in her ruling, she quoted the decision deeper, word for word. So she was ready. She was testing me. Had I gone without mastering the law, I'd have looked like an idiot. So you must master the law. If there are 20 cases on the subject, read all of them. And in your mind, arrange which ones are best. And even the ones that don't support you, so you can distinguish it if a question comes up to you. Master the law. And when you master the law, the third thing is to think. Create thinking time. Sit up. I want to think, what am I going to do with this? How am I going to do this? Which is the best way to present what I have found? Because it is in the thinking process that you weave everything together into the presentation that you make. One trick. When you have thought and you have built your case, do what is normally called the off-script. Off-script is when you are ready and now you argue against your case. Have an honest and emotional review of your work. How will the opponent see it? What are the possible arguments against this? Now, I don't worry about challenges at all. I encourage the young people, come to me if you disagree with me. It does one of three things. One, it might make me realize that my position is completely wrong. Then I begin to think about settlement. Two, it might bring in aspects, it might challenge little bits of things that I need to tighten up to make my case better. So that by the time I arrive in court, I have thought of everything of that counsel on the other side will bring. And the third one, it will make me very confident that, oh, as an Ankomah, I mean, there's nothing anybody can say that can mess it up. So don't be afraid of pushback. When your senior pushes back, don't go and hide in the kitchen and cry. That's not the way I think that you've gone through it already. All right, let me end with this. Help your seniors. One thing, if you know your senior is going to have an argument and you'll be given the file, prepare speaking notes for him or her. So, senior, tomorrow the argument. I have a suggestion on how to present them. Please, in disputes, we don't have shy lawyers. If you are shy and you think that, no, do corporate, do transactional law, do advisory law. Now you are advising from behind the computer. But if you don't go and stand before a third-party neutral, you have to rid yourself of all that fake shyness. You said humility. I like humility. I don't like the Ghana version, humbleness. That's what I call it. Where you are supposed to. I don't understand that thing. Disputes, your forehead has to be strong out there. So prepare speaking notes that these are the 5 issues. These are the facts that support it. This is the law that supports each of them. Give them a 3-minute summary of their arguments. Your senior say, hey, okay. The next time, very soon, you become the one evolving these things, and you realize that you're helping yourself. And so I'll say that I was ending with this. When you get to the courtroom, watch what happens. Take notes. One of the things I do with the juniors in the firm is that when we're going back, I ask you, what did you learn in court? What did you learn in court? Did anything happen? In fact, we encourage them, when they come back to court, to send a note out. that today I was in court and these arguments were made and I don't understand it. Then we can have a conference on it and we all learn. Prepare the speaking notes. Last. Have a summary of your arguments in mind. It's called the elevator experience. Now, this is how I explain the elevator experience. It's Friday. You have a hot date. As for this date, it is the date of dates. That tonight, either he's going to propose or you are going to say yes. This is the date of your lifetime. At 4:30, Raymond, your boss, comes up and dumps a file on your desk and say, can I have a memo on this by Monday morning? When you look at the file, at the size of the file, your date is gone. It's gone. You have to send text. Oh, rain check. You stayed in the office till midnight Friday. You come in on Saturday, work all of Saturday, come in on Sunday. At Sunday night or at dawn, 2 a.m., you send the memo to Raymond that, Ray, Senior Ray, I'm done. And guess what? He doesn't mind you. Monday passes. Tuesday passes. You are like, but Senior Pa, it means I could have done this work on Tuesday. I missed my dates for nothing. I'm telling you a serious thing. On Friday at noon, just when you're about to go and have lunch, Ray comes and says, I'm going for the meeting now. Ride with me down the elevator and tell me about what you wrote, which means he hasn't read it. Now, are you now going to sit there and say, okay, the facts of the matter are, the issues are, by the time you are done, he sat in the taxi and left, and he's saying to himself, I'm not giving him a job. What do? Reduce everything into bullet points. So he asked, what is it about? He said, Senior, there are 4 matters. 1, whether or not this, or actually, you're not even asking questions. 1, the client has a course of action. 2, the course of action is based on this. 3, these are the possible reliefs. 4, this is the court we are going to file it in. By the time you are done, he sits in the cab. He says, wow, what a brilliant associate. I made a mental note. So the next promotion, I'm going to promote her. Learn the elevator experience. I have seen many lawyers mess up their cases in the Supreme Court when the court has said, you have 5 minutes. And a very senior lawyer was standing there to sat down. The young lawyer got up. He knew the elevator experience. My Lord, there are 3 things here. Stated what they are, finished, sat down. And even though the senior won, you could see that the judges struggled to give it to him simply because he had a good case. Had they been on that day's showing, the young man would have won. Learn the elevator experience. But this is just 10 minutes. I have a lot more to share. But if I share it with you, many of you are in my opposing firms. No, that's not true. I'm very, very, very willing to share. And so maybe another time I'll take you through things like how to become the 10 steps to becoming a good attorney. Right? I have stuff like that. We'll do that at another time. Thank you very much. Thanks for your time.